And you have a good day, sir. Thank you.
690.
Okay, so let me go back. That would have been Exhibit 687.
Correct, but 687 was originally the Instagram business page.
Okay.
1189.
All right, so what the court, during the testimony, which I believe was the cross-examination of Mr. Mango, what was Exhibit 687, and the clerk has held that up, and that would be the image from the restroom wall at Racy's,
Correct.
is now 690, is that correct?
Correct.
So that's received, but it's been renumbered as 690, not to be confused with a different exhibit. Okay, and with that, ladies and gentlemen, we're going to excuse you. All rise, and we'll have you back in shortly after 1 p.m. All right, we had a number of sidebars during the testimony of Mr. Mango, and let me go back. Okay, so beginning with cross-examination today, there was at 8:59 a.m. a sidebar. Again, Mr. Hahn and Ms. Vishney, these were all Mr. Hahn and Ms. Vishney. And the court had sustained an objection about prior inconsistent statements. And this related to, I think the objection was related to what Mr. Mango was saying about what he thought Ms. McCandless thought. Mr. Mango thought about the abortion. Counsel wish to elaborate on that sidebar?
Sure, we spent a lot of time with you, and I don't remember exactly
Okay, well, I think,
additional information there was, but that sounds familiar.
okay, well, if I remember correctly, it was, the question was, Mr. Mango was asked whether Ms. McCandless had the impression that Mr. Mango did not want to have a child. And the objection was based on Mr. Mango testifying about what somebody else thought or what their impression was. And so I sustained that objection. The next was Mr. Hahn objected to a question that Ms. Vishney had asked, and it related to Ms. McCandless, what she had said to Mr. Mango at the clinic or near the clinic or in time when the abortion took place. And the court overruled the objection based upon it being a hearsay exception, then existing state of mind, which is section 908.03 subsection 3. Anything further counsel would like to say about that objection?
No.
Okay.
Correct.
Then there was 9:12. Mr. Hahn objected to a question Ms. Vishney asked about, essentially it was how Alex felt about Mr. Mango, and again, the objection was based on, essentially, witness can't testify about what another witness was thinking. I think that's basically a personal knowledge objection, speculating, and that was sustained. Any further follow-up record on that?
No.
Ms. Vishney?
No.
Okay. Okay, then 9:21, there was a sidebar, and this was, if I recall correctly, and again, it's taken down by the court reporter, so if I'm incorrect, that can be, I guess, addressed at a later time. But in any event, this related to questions about, there was a series of questions Mr. Mango was asked. It started with him being asked about whether Mr. Woodworth was saying that this injury that Mr. Mango had bandaged was caused by something else, a burn at Racy's or something along those lines. And there was a hearsay objection related to other people, what they were saying about Alex wearing the bandage. court sustained that objection. Any further record you'd like to make about that?
I think that what I argued to the court at that time was that it was a then existing mental, physical, emotional hearsay exception. I believe that's the one that I argued that.
Yeah, I don't remember hearing the argument about a hearsay exception.
I know I argued a hearsay exception. With respect to that, I also argued that that was something that Jason Magel had previously said, and it was being done to impeach his credibility because of his motives or bias in the case as to how he was testifying about Alex Woodworth. I also argued that.
Okay, that I recall, that you were in the area of trying to show bias of this witness.
Right.
But in any event, the court sustained that objection because, as I saw it, it was just basically gossip that secondhand information, Mr. Mengel did not have firsthand information about that. He didn't observe it, and it wasn't what Alex had said to him. It was what Mr. Mengel had heard, so it was basically just gossip. Right. So that was sustained. Mr. Hahn, anything would you like to say about that?
No.
Okay, then at approximately 9:34, there was a sidebar, and this related to, there was an effort to, there was basically, it was a tale of two transcripts from the same interview. And Mr. Hahn was just concerned that what was being used by Ms. Vishney was accurate, and basically there was an agreement that Ms. Vishney would use the portion of the transcript that she had, her version of the transcript, and there was really no confirmation as to whether the two transcripts were exactly the same, and I think that's what Mr. Hahn was requesting, just to make sure he had the correct transcript. And but Ms. Vishney was allowed to use Exhibit 689 to refresh the recollection of the witness.
That's correct, Judge. I would have preferred to have used it as impeachment, but the same goal was achieved by using it to refresh. And I just want the record to reflect that the reason the defense used its own transcripts is because they not only have page numbers but line numbers, and every minute or two they have the time inserted where on a tape that those things happened, and I had provided a copy of those to the state yesterday.
All right. Okay, and then at 9:41 there was a sidebar, and it was really, again, Mr. Hahn and Ms. Vishney, and Mr. Hahn's objection, and the discussion at the sidebar was really about getting to using a prior inconsistent statement of Mr. Mengel's, and without some of the objectionable content of it. So, as my note was that Ms. Vishney was allowed to use this prior inconsistent statement about Ms. McCandless being impressionable without getting into Mr. Mengel's opinion about what the personal philosophies were of Mr. Hansen or Mr. Woodworth in the area of nihilism or whatnot, but just that he had said during direct examination yesterday that she was not impressionable, as I understand it, and this area was prior inconsistent statement of Mr. Mengel being used, that he had had discussions with Ms. McCandless concerned about her being impressionable in talking with these gentlemen in their philosophies.
That's correct, and just to clarify the record, what I would have asked had I been allowed to was basically that Mr. Woodworth and Mr. Hansen were into nihilism, and that their philosophy is essentially that there are no rules in life. The exact words were a little bit different, but that there are no rules, and that Ezra McCandless was young and impressionable, and hearing those things from these two men.
Okay, and that was, again, that was the content, as I recall, along those lines. Mr. Hahn, anything you want to add to that?
Not to the content of the sidebar, but I think the testimony was a little bit different. I believe it was during cross-examination that Mr. Mengel said that the defendant wasn't vulnerable, and then the question, again on cross-examination, was whether she was impressionable, and that's what he had previously said. So it wasn't a complete inconsistent statement, but the same purpose was achieved by the sidebar.
Okay.
Yes. Yes, but I just wanted that the court did exclude what I would have asked on cross-examination, which was that Mr. Hansen and Mr. Woodworth were part of a philosophy that there were no rules, and that the court did not allow me to ask that specifically. And so that's not going to appear on the record because that was all stated at sidebar.
Yes.
I just want the record to reflect what I was trying to get in.
Yeah, and I just want to give you that opportunity to make that record.
Thank you.
Okay. Then at 9:52, there was a question about Mr. Hansen being a heavy drinker. Mr. Hahn objected on relevance. The court sustained that objection. We had a sidebar on that. Anything further you'd like to say about that, Ms. Vishney?
Yes, I was attempting to elicit testimony that John Hansen was a heavy drinker. I had a good faith basis for knowing that he was a heavy drinker, and I was going to ask Mr. Mangle about Mr. Hansen approaching people and suddenly choking them at parties when he had been drinking, and that he was engaged in similar conduct with Ms. McCandless, and that he was drinking all the time back then, and the court did not allow that question. I explained at sidebar my good faith basis for that, and so it wasn't speculative on the defense's part or simply trying to show off or imply facts that weren't true.
Okay, and again, I agree with your characterization of what the defense offered, but again, I sustained it on relevance. And part of the argument Mr. Hahn made on the sidebar was that in the incident where he observed Mr. Hansen putting the defendant in a headlock, which I was also, I guess, event number one in the Officer Vang interview that was discussed, that there was no alcohol involved in that particular incident. In any event, there were a lot of questions back, regarding the headlock and the break-it seminar or whatever, but in any event, I think that was what occurred at that sidebar. Okay, so then at 10:03, there was a sidebar, and I think there was an objection by Mr. Hahn to the form of the question, and Ms. Vishney had used the word facts, that Ms. McCandless had given you facts, and Mr. Hahn objected to the form of the question, and that was sustained, and essentially Ms. Vishney was redirected to just ask what Ms. McCandless had said to him rather than, the argumentative putting it as facts. And anything further you'd like to say?
No.
Yeah, Ms. Vishney, Mr. Hahn?
No.
Okay. All right, then the other sidebar, I think we cleared up at 10:30, approximately 10:32, 10:34. The sidebar was getting long, and we ended up excusing the jury and actually just having a hearing outside the presence of the jury. And when the jury returned, the court advised the jury that the objection was sustained, and that related to the questions related to Mr. Mangle's observations of Ms. McCandless in 2017 at a hospital following a automobile mishap. Anything further you'd like to say about that? I mean, we've already, I think, fully aired that one.
Yeah, that's correct.
Okay. Mr. Hahn, anything further on that?
No.
Okay. Then at 11:21, there was an objection I believe the question was by Ms. Vishney, objected to by Mr. Hahn. It related to a question that was asked about, now this was the second time within a month that the police were called on you, and as I recall, Ms. Vishney wanted to offer that for purposes of showing the bias of the witness, but because Mr. Mangle had testified, first of all, he didn't know who called, or that the police were called about him, related to when Mr. Trankler called the police, and the court sustained the objection. Anything further you want to say about that, Ms. Vishney?
It was my impression more that Mr. Mangle didn't know who had called the police when he was at Mr. Woodworth's house, but at least that's what I thought, but not referring to Mr. Trankler. I think he knew that Mr. Trankler had called the police at Mr. Trankler's house.
All right.
But
Well, I
that
think
was,
he knew who called the police, but he didn't realize that, his testimony was, as I recall it, was that he didn't know that Mr. Trinkler called the police because he was worried about Mr. Mengel. He thought that Mr. Trinkler called the police because of the reporting that the sexual assault had occurred.
well, he said that I would impeach him had I been able to do it, and I think I did that somewhat before, that he had gone ballistic, and that's when Josh Trinkler called the police because he was threatening to kill John Hanson, and that this went to his bias and that he was minimizing his own behavior, and that what I was attempting to show was that he was engaged in similar obsessive behavior as it concerned Ezra McCandless and another man on March 22nd. But in any event, the court did sustain the objection.
Okay, Mr. Hine, anything further you want to say about that?
No, Judge, thank you.
Okay, and again, anything else, Ms. Vishney, that you?
Just that I think I made it very clear in sidebar that my issue was bias, that's all.
Okay, very well. All right, and I believe that clears up all of those sidebars from
Thank you.
this morning. Okay, then we'll be in recess. I think we'll give counsel at 1 hour.
Thank you.
Is the defense going to offer the portion of the video that's been played?
I will
Are you
get
going to give a new
Yes.
drive or something?
Yes, we're going to do that to clear up the record.
Yeah, unless I can put it on the exhibit that I already had. I've submitted a thumb drive, Your Honor, that has the digital recording, I believe, from Mr. Vang. Does anyone have an objection to me just adding to that thumb drive, or do you want an additional thumb drive? Can I put onto that thumb drive an additional digital file, or should we have separate thumb drives for each digital file?
Well, if it's a different exhibit, if it's not closely related, because I don't think that those were, because that was, as I remember, that was a recording of an interview with Investigator Dykus and
Absolutely
Sergeant
correct.
Meyer. Meyer.
Absolutely correct. I just want to know if you,
I think it should be separate.
okay, we'll do that.
Okay, and that will be 688, is that right? Okay, so at some point we have to advise the jury that exhibit is 688. Okay, and we'll be in recess.
Thank you, Josh.
Two things, maybe a third. Mr. DeFore ran out to try to deal with the third, so I don't know if the state's comfortable with me going ahead with the first two without him here.
That's fine.
One is I have put on a thumb drive exhibit 688, which was the playing of DOJW recording during Jason Mengel's cross-examination. It's the full recording that has been submitted. I know there was only a portion, and I believe we put on the record when I played it what that portion was. I don't recall it off the top of my head.
All right.
Second and
Okay, go ahead.
other issue, Your Honor, is we talked about, the defense did when it comes to the defense's time to put on evidence, our intent to play two recordings, one from Trooper Knutsen's squad cam, a second from Deputy Emmer Shields' squad cam. The defense has prepared a 7-page, what I'll call legal memorandum to just get the conversation started. We typed it up. I apologize, I don't have the ability right here in this moment to e-file it if Your Honor wants us to over the weekend or at some later date, but I have a printed copy. I've given it to the state already. Can I give it to Your Honor?
Yes. And then
So
you are going to follow up with the e-file?
if that's what Your Honor asks us to
Yes,
do,
yeah,
we can certainly do that.
Part of the record, yeah.
Okay.
I mean, I think in terms of, with the caption and.
We'll get it
proper format.
filed tomorrow morning, probably.
Okay. All right, the third?
Just on that, just 1 minute.
Okay.
On the written submission that I have, I think we put body camera footage, and I apologize, that's inaccurate. It's a squad cam footage, and so I just wanted to make sure that that was accurate, and obviously, I imagine everybody's going to want to make verbal arguments. I, again, just wanted to start the discussion.
Very well.
The third matter was at some point, I believe, when Michelle Wright testifies, if I recall correctly. There are a couple of displays that the state wants to be put into evidence. I have an objection to 2 of those displays. Whenever Your Honor wants to take that up, I am prepared to do so. And then lastly, Jenna Vandezande, I believe is the state's next witness, and there are two exhibits, one of which is the Exhibit 519, which is the note that has been much discussed, that was found in the Impala. And so before she testifies, we should just take that up.
Is she the next witness or who?
Yes.
All right. Okay. So as the proponent, what is the state's position with respect to the Vandezande letter?
Are you objecting to both exhibits or just the?
Yes, I'm objecting to both exhibits as hearsay and irrelevant. Exhibit 519, which is Jenna's letter to Jason. Again, I don't believe there's any probative value to that. Exhibit 405, Your Honor, is a series of electronic communications. I don't know under what form, whether they're texts or Instagram or what, but electronic communications between Ms. McCandless and Ms. Vandezande on February 5th of 2018. So again, I don't think that those are relevant to anything that happened in March. I believe there's communications are about Ezra's relationship with Jason.
Okay. Who is handling that for the state?
I am, Your Honor. I'll first go with Exhibit 405 that the state intends to introduce. Messages that Ms. Vandezande saved between herself as well as the defendant regarding the defendant's feeling over Jason, and some messages about her moving out of the apartment. I think it's highly relevant. She can authenticate them. I think it's relevant to her state of mind. We've had a lot of information and testimony about it. Ms. Vandezande was Alex Zink's girlfriend, friends with the defendant. I think it's certainly relevant to show the defendant's statements and, it goes to, I guess, again, state of mind and motive and intent leading up to the event in question.
All right. And do I have?
No, Judge, I can provide you with one. The first portion is blocked out as it just contained her summary.
Again, the court believes that this thread conversation, if it's authenticated between the defendant and Ms. Vandezande, would be relevant as part of that panorama of evidence surrounding the circumstances leading up to March 22nd, 2018. And so, again, if properly authenticated, court believes that, or will admit, Exhibit 405. And the objection by the defense is noted, preserved for the record. Now, with respect to 519, is that offered? I looked at it, and I believe we have two exhibits. We have the actual letter plus a photo of the letter. And is 519 the photo of the letter that Crime Lab produced? All right, and so go ahead again as a proponent of that letter. Go ahead, Ms. Nodal.
Judge, I intend to actually introduce the letter itself, which I believe is Exhibit 677. It was located in the defendant's car following the incident in question. I believe Ms. Vandezande will testify that on March 19th, she had a conversation with the defendant following a conversation Ms. Vandezande had with Jason Mingle, where, I guess to summarize, I anticipate she'll say the defendant was upset with her. And so following that conversation, she wrote this letter to Jason Mingle. And then she actually took a picture of it to save it in her phone, so she had documentation that she had done it. And then it was later located in the defendant's car. Jason Mingle has already testified that he gave that letter to the defendant. He remembers seeing it on the front passenger seat of the vehicle while the car was idling at Alexander Woodworth's house. Again, I think it's very relevant to this case as well as the contents. I wouldn't say there's anything mind-blowing in the letter. It's essentially like, you know, you guys need to talk and I'm staying out of your relationship, essentially.
So is the letter being offered for the truth of what's in the letter, or as evidence surrounding the relationship? I guess it's a different analysis. If it's not being offered for the truth of the contents of the letter.
Yeah, I mean, I kind of think it's both in this case. I think the content is relevant. I mean, I have a copy of it. It's hard to read. If the court wants to, do we have exhibit, is it 570 something? I don't have.
677 and 519?
519, yeah.
Yeah, I guess I'd like to
Okay,
take a
so
look
you're
at the
on
exhibit.
519.
Thank you. And then, any response then from the defense with respect to that letter?
No probative value.
Well, again, given all of these circumstances, it goes, in the court's opinion, to, all of the drama and turmoil and circumstances leading to the emotions, the fact that it's in Ms. McCandless's automobile on that day, and again, it relates to feelings, which in the court's opinion are significant because that seems to be at the heart of her having contact with Mr. Woodworth, and does go to the defendant's state of mind. And so the court believes that getting it properly authenticated, that would be admissible as well, but not necessarily for the truth of the matter in the letter. I don't know, I haven't heard a hearsay exception as it relates to I think the fact that Ms. McCandless had the letter, and that there had been this apparent problems, drama, however you want to characterize it, between Mr. Mengel and Ms. McCandless. Again, I'll go back to, as it was described by Mr. Mengel to the police officer, he used the word situation. It goes to the situation, which, again, is the source of the turmoil and so on that Ms. McCandless wrote about. But I don't know what in this letter would need to be received for the truth of the matter in the letter itself. At least until I've heard what Ms. Vandezande has to say about this. I mean, there's some reference to, and I'll quote, "I think I've been operating from a place of miscommunication and not having much of the whole story until now after talking to her," which I assume is Ms. McCandless, based upon the proffer. So, depending upon the testimony of Ms. Vandezande, the fact that Ms. McCandless had the letter, and Ms. Vandezande can testify to what Ms. McCandless said about those things that the court has ruled would be admissible about the circumstances surrounding these relationships as described in the court's pretrial ruling, provisional ruling on evidence. I'm not going to elaborate, but again, as part of the panorama. And so that's all I will say on that at this point. Do you want these exhibits at this point? Okay, I'll give those back to Ms. Nodoff. And I would like to go back to this Michelle Wright. You indicated some displays that you were objecting to, Mr. Nelson.
Yes, Your Honor.
Can you give the court some idea of what?
Can I grab them? They're the state's display, so I don't want to.
We'll start with this one.
Your Honor, the defense objects to this, can you grab it? Thank you. I think it's been marked as a plaintiff's exhibit 418, which is entitled Alexander Woodworth Homicide Association Chart. There's a photo of Ms. McCandless displayed there. I don't know where that photo came from. I do not think it accurately portrays what Ms. McCandless looked like on January, February, or March of 2018. Her hair is in a much different length, and I think that that's an important fact in the case to some degree. And there's also in this photo, she's got a ring in her, I believe it's called septum, commonly known as her nose, and that picture isn't in evidence. I don't think they need to put a picture of Ms. McCandless with a nose ring appearing in a way in which nobody says that's how she looked any time around this matter into evidence. I think it's not probative, and I do think it's substantially unfairly prejudicial under 90403 because it does not, first off, it's not accurate, and it portrays, I think, again, the ring, which I think that's unfairly prejudicial.
Your Honor, and I tried to find, right, because I wanted to be sure where the photo came from for sure, and I don't know that. I couldn't find her. I thought initially, and I may be wrong, but I thought this was her driver's license photo. It may not be, it may be. If it isn't, it came from some of her Google accounts or Instagram accounts, which are part of the record, although they haven't been displayed to the jury, they are part of it. But I think we need to ask Ms. Wright for sure where the photo came from before we can make that, before the court can make a ruling on whether or not it is or is not admissible and should be admitted. So I will try to find her as quickly as I can.
Has that been marked as an exhibit?
It has been marked, it's exhibit 418.
She's here.
I will try to find her as soon as we're done with this, and okay. All right. I will go find her. We can get started on the next witness, that's fine. I will just come back in as soon as I do it, and we have a break, or we can do a sidebar on it. We can explain that, so.
Then, what's this exhibit number, sir?
This is 424.
424 is labeled Alexander Woodworth Timeline of Events. I don't know if Your Honor can see it from there. Can you bring it up closer?
I can't see the small print.
So, however, sorry, we'll team approach, I guess. I can grab it right there. As Your Honor might be able to see, there's text on there, and I don't think I'm not disputing the times, nor am I disputing the pictures, but the text in black is not always accurate to what the testimony is. Take, for instance, the time here for when she shows up. That's based upon a report that may or may not be, nobody said when she showed up. Nobody said,
All it is, it says janitor calls 911 after Jason shows up at Alex's house. The call is at 12:34 p.m. That's all accurate, Your Honor, and that's all based upon testimony that was received.
to be honest, I don't recall if there was testimony when the 911 call was made. It's the blue writing that says PD report on that portion that I object to. The language here where it says Ezra's car is seen again in the area of Alex's apartment. I don't think they can say in the area of Alex's apartment if they want to argue later, but they can say Alex's car is seen at Madison and Bellinger. That's a fact.
No.
And so those are the matters that, and again, over here where it says seen again in the area of Alex's apartment, again, nobody said it's in the area. They gave specifics on a route or some other things, and they can make that argument, but I think to put it in an exhibit, it implies that that in fact is a proven fact that it was in that area. And so they can just say, here's what the video, show the picture and show the facts, but there doesn't need to be commentary about that. And so that's what my objection is, Your Honor.
And Investigator Streeter testified, in fact, showed on the map exactly where this is, and showed that it was in fact near to Alex's apartment at those various times. He testified to that. He specifically testified that this was the route that would make most sense. Going to Alex's apartment, he showed on the map where it was, and he showed where Alex's apartment was, in relation to where these photos are from. So that's an evidence. And evidence is that that's the time that the 911 call was received at the Eau Claire Police Department. That came in through, I believe, Officer O'Neill, what time the call was. So all of that is in evidence.
My objection to the language is the language near and the language in the area. I don't believe Officer Streeter used that language. He used language similar to what Mr. DeFore just said. The route from here to here goes through this intersection, but that's not what's on the display. They use other language than what that was.
In the area of near, I don't know what the difference between the two is, Your Honor.
Well, I'm objecting to both, so whether there's a difference or not, I'm saying that that's not in evidence. The evidence, if they put on there, if they put on there the testimony, which is this photo is on the route between Stanley and the Cameron Street address. This photo is on the route between Racy's.
Counsel, there was a map, and these locations are within just a few blocks of where the 511 Cameron Street address is, as I understand it. But, okay, so thank you for the preview. We will take that up when you have that witness. Okay?
I'm going to go talk to Ms. Wright. That's fine to bring the jury, and I'll be right back.
Okay, so Ms. Vandezande is next. Okay. Let's bring in the jury.